Good morning, Ms. Eisenhower.
Good morning. May it please the Court, Rachel Eisenhower for the Commonwealth. With me at council table is District Attorney Sam Sutter. This morning was filed in the clerk's office an amicus brief by CPCS in this case. I don't know if you've received it yet, but page 2 of it has 6 very interesting questions that I'd like to start out by answering those questions if the Court would permit me. First, unlike all of the other offenses listed, committing a possessory firearm offense does not involve harm to a victim or use of a dangerous instrumentality or the use of force. I disagree. Burglary and arson also don't involve direct harm to a victim, but create a situation in which harm is likely to occur. Similarly, carrying a firearm on a street or even possessing it creates a similar dangerous situation in which harm is likely to result to the community. In particular, the Hines case in 2007, or I guess it was 2008, demonstrated that you don't have to directly fire a gun for it to have some purpose in your criminal activity, and that creates a danger to the community. B, there is no nexus between possession of a firearm and actual use, because neither use nor handling is an element of the offense. While it is true that there is not necessarily a nexus between possession and actual use, there's certainly a nexus between possession and risk, and it is risk that Section 58A is concerned with, rather than actual use. It speaks of risk of harm, not whether that harm manifests. It speaks
of substantial risk.
Yes, substantial risk. And that arises not only from use, but from situations like the one in the Hines case, where something is used to further a drug dealing business. C, committing the offense does not.
What about is it the Dillard case or Dilliard case?
Dillard out of the Second Circuit.
Yeah, is that the case that distinguished, at least under the federal statute, between possession and felon in possession?
Yes, they did rely heavily on the fact that there was a felon in possession.
Yeah, possession really doesn't create a substantial risk, whereas felon in possession, I think fairly well reasoned, changes the nature of the crime.
They did rely on that. However, the residual clause in the federal BRA is much more stringent than the one in Section 58A for a variety of reasons. The two main textual differences between the federal residual clause and the state residual clause is that the federal residual clause uses the word use. It requires some sort of active agency by the defendant, that he be
But
the
we're
person.
still talking substantial risk. I mean, the interesting part of the case was the analysis of substantial risk, and one that was picked up, I think, by Magistrate Swartzword in a more recent case.
I agree, Your Honor, but substantial risk can't stand alone. Substantial risk of what always has to be the question.
Substantial risk of the use of force.
But in the federal case, it's substantial risk that force may be used. Here, it's substantial risk that... Pardon?
I mean, that's the federal one has that in the course of committing the offense.
And in the course of as well. That's another element of the language that's different, both in the course of...
So do we have any sense of how many arrests there are every year for unlicensed firearm, and how many of those involve, for example, the use of force?
I don't know that.
Any sense of how substantial the risk is at all, other than just probably, maybe, could be? People use guns against other people, so if you have one, you probably substantially
there
likely.
There are no factual statistics in this case that the Commonwealth filed. However, I think that we should look at it as an issue of foreseeability rather than probability.
I take it, though, that the Commonwealth doesn't argue with Justice Cordy's assumption that the Commonwealth would say any time you've got an unlicensed gun, in any circumstances, you can have a dangerousness hearing.
Well, I think that the issue, to answer the question, the structure of the statute is first that there must be a predicate offense, and then second, a factual hearing. Certainly not all factual situations in which there's possession of an unlicensed gun will merit pretrial detention. But because we use a categorical approach in determining whether a felony falls into the residual clause, I would have to say that it goes to the elements of the crime, and so we won't be able to take into account whether it's a factual situation. That has to be left up to the discretion of the district attorney to decide whether to move at all. And presumably,
So I take it that your argument then would be that the only constitutional challenge that one could have is an as-applied challenge.
An as-applied challenge under vagueness, or you could probably, yes, I think it has applied challenge.
I have a question about what happened in this case. The judge gave you the requested hearing, so that would suggest that he found that this was a predicate offense. But regardless of that, you had a hearing. And the only evidence at the hearing that you presented, is that correct, was that he was found to be in possession of a gun, and then a reference to some other charges for which he was in default.
Yes.
So you didn't present any evidence in essence other than the carrying of the gun.
That is true, Your Honor. I would note that the judge did frame it as a legal ruling, and I was wondering myself why he conducted the whole hearing prior to the legal debate, and I realized that the trooper was there waiting and being paid on Commonwealth time, so he probably just decided as a matter of court administration to take the evidence.
Oh, it's always better to know what the factual record is, even if you're reaching a legal. I think that's a very...
That's true. That's true.
But also, from his view of, as I understand it, from his view of the statute, he would look at to see if there's a predicate offense, or it comes within the residual clause by considering the facts of the case. I mean...
He may have. He may have. And I would say that...
I mean, I thought that was part of your argument,
that
was
it is
incorrect.
Argument one.
Right.
Yes, and my argument is that that is an erroneous thing to do.
Right, but if that was where he was starting from, he would have the hearing to do that.
Oh, yes.
That's
yes.
all I mean.
Exactly. Had he, and as he probably did, because he did it twice in each of these cases, he probably did enter the hearing with that understanding of how the statute works.
Okay, I just want to get clear. So you're saying that in every case where someone is charged with unlicensed possession of a gun, that's all you have to present at the dangerousness hearing to get the denial of bail?
Well,
are you saying that? That's my question.
Well, I'm saying that that's all you need to satisfy the first prong.
No, I understand that.
Okay.
I know that. I'm over that. But because of this hearing that you had, you didn't present any other evidence other than some outstanding charges.
Ideally, the Commonwealth would present evidence sufficient for the judge to find all of the elements listed, and I believe it's 58A4, that talk about the previous factors, the record.
Well, okay, what I'm getting at is if we were to agree with you, that the gun possession is a predicate offense, then what do we do here? Because you already had a hearing. You didn't present very much, it seems to me, to show dangerousness other than the fact that he was carrying the gun. And therefore, are you saying that we should reverse and remand it for another hearing?
I would not. The Commonwealth's had its opportunity. I think it would be satisfactory to remand it and have the judge enter a factual finding on the basis of the record of that hearing. Because clearly, as he said, he credited the trooper. He made the factual findings on the record for the benefit of this court. And it's clear from the record that he anticipated an appeal by the Commonwealth. So I think that it would be unfair to give the Commonwealth a second bite at the apple at this point. But there is enough evidence, and he can make the decision whether he feels that that's an appropriate situation or not.
Now, I take it we look to the offense as defined by the statute as to whether or not it's a predicate offense, not the offense as committed by the defendant.
Exactly, Your Honor.
Okay. The statute does not require for a conviction or even for the indictment that there be any bullets in the gun, right?
No, it does not.
Okay. So what's so inherently dangerous about an unloaded gun?
Well, it depends on the statute you're talking about. Section 10A of Chapter 269 does say loaded or unloaded. Mm-hmm. So there's always the possibility with firearm safety, you may not know whether it's loaded. The assumption that a gun is unloaded is one of the most dangerous things about firearms.
But what was he charged with?
Which one? There are two.
Was he charged with possession of a loaded or an unloaded gun?
Rodriguez was indicted for a large capacity feeding device, a defaced serial number, and carrying under 10A. I don't see any. He
wasn't charged with possession of a loaded gun. So what's inherently dangerous about an unloaded gun?
Well, in the case of Rodriguez, the gun was in a backpack with drugs, so presumably he was using it to protect his drug dealing business, and if it wasn't loaded, then it was for the sort of the Heinz value, if you will.
But isn't the danger in an unloaded gun that the person you pointed at doesn't know that it's unloaded? And
Oh,
that
exactly.
he or she will react as if it's loaded. It's the same as the distinction between armed and unarmed robbery. It's simply the use of a gun. It doesn't matter whether it's loaded. It's because we try to deter or we punish more severely the person who shows the weapon, because the victim may react to what is perceived as a gun. One doesn't stop and think whether it's loaded or not.
I agree completely.
Well,
Rodriguez still, I'm sorry, is he still in default?
Oh, no, he is no longer in default. He was at the time of the filing of the brief. Rodriguez, I believe, is held without bail, though bail was set December 15th at $50,000.
Ms. Eisenhower, could you help me
Yes.
on one piece of your brief? You set out the different elements under 58A, and then compare them with the federal, and then you have and the fourth factor is one where the Massachusetts statute is broader, but you have an interesting way of describing it, and I really didn't know what you meant. Element 4 requires a causal connection between the offense and the potential risk, is your position. That's the may result. And then you said that a risk may result does not require that it be the defendant who personally creates the risk, merely that he set in motion a chain of events in which the creation of risk is foreseeable. What
Yes.
on earth does that mean?
I apologize for my writing.
No, I'm trying, it's not that. I'm trying to understand. We don't detain people very easily before trial.
Exactly, Your Honor.
So you're on a big uphill burden here. Now you're telling me it doesn't have to be the defendant, and it's just something that may happen.
Certainly, the crime itself has to be by the defendant, both in the federal residual clause as in the
So an unloaded,
Massachusetts.
unlicensed
Well,
gun.
whatever you're being detained for has to be your own action. You can't be detained for the acts of your friends. But when you're assessing whether something's dangerous enough to be detained, the danger, the risk, should be assessed not only by what the defendant might do, by what he foreseeably might cause others to do.
That's what Justice Cowan's talking about.
Yeah.
Yes.
The reaction of the victim.
The reaction of the victims, the reaction of co-compatriots. They might be emboldened to go on, just as the victim might react in fear.
But this is a possessory crime.
It is a possessory crime.
He's not charged with assaulting somebody with an unloaded or a loaded gun. He's charged with possession of an unloaded gun.
Yes.
Well, can I get back to that, though? At least I'm reading the brief here. I thought that Young was charged with carrying a loaded firearm in
He is
violation
charged with
of
carrying.
carrying a loaded
Yes.
firearm in violation of 10N,
Yes.
right? Okay, so we do have a loaded firearm here, at least with respect to Young.
I would mention, though, Your Honor, is N a felony?
N?
I thought N only had 2.5 years in the House of Correction.
Okay, so so that's 2.5. That sentence is from and after the expiration of a sentence in A.
Yes.
So A is the key thing here,
A is
simply
the key
carrying
thing.
loaded or unloaded.
Yes.
All right. What about carrying a large capacity? Is that also a non-felony?
That large capacity is a felony, I believe.
Okay. Well, do you think, and Rodriguez is charged with carrying that, do you think it makes a difference between just the possession of a firearm and the possession of a large capacity firearm in terms of substantial risk?
Certainly, capacity is more risky, but it only takes one bullet to kill you, Your Honor.
No, I understand that, but do people who carry large capacity firearms without licenses, are they more likely to use force in connection against another person?
I think anyone who carries an unlicensed firearm is taking a risk into the community, whether it's a large capacity
Well,
or
I go
not.
back to the federal analysis saying a felon in possession, that charge simply creates more risk because felons in possession are more likely to use those guns against persons.
Precisely, Your Honor. But the Dillard court was assessing this under a different text.
I understand that.
We have floating at some point some constitutional limits on this, but let me make sure that I understand your argument. Your argument is that anybody who carries an unlicensed, unloaded, small capacity firearm can, in the discretion of the district attorney, be subjected to a 51A hearing,
Yes, Your Honor.
58A hearing.
That is my argument.
At least you are frank.
I notice we have a minute 50. Would you like to talk about
The time is yours.
Well, I would ask you the question, would you respond to the constitutional issue that the defendant raises regarding Heller?
I think until the Supreme Court acts, Crookshanks governs. I mean, the writing may be on the wall.
Till it acts, what was the next word you said?
Until the Supreme Court acts to overrule its 19th century precedent in Crookshank, I think that Crookshank governs. I mean, it's certainly the
Why?
writing. Well, because it's a Supreme Court precedent on a
No,
federal constitution.
why does
What
it
you-
govern? Not that we can overrule it, but why does
The
it?
Second Amendment is not incorporated, isn't that right? Or the
Yes,
Crookshank?
the Crookshank holds that the Second Amendment isn't incorporated, and that's a valid Supreme Court ruling.
And
until
Heller involved the District of Columbia law, which
It
I
did.
assume is
It did, and
federal.
it certainly had some language that suggested that
It may.
it well may, and it seemed to view with a bit of skepticism the idea that Crookshank, which also had the First Amendment, wasn't incorporated, would survive scrutiny under the Second Amendment. But they haven't done that yet, and I think that when they do, they may announce some test about whether
If they do.
when they do and if they do, I mean, whatever. They may announce some test in that holding about how we should go about evaluating all the state gun legislation. So one of the problems with preemptively helping them overrule Crookshank would be...
Cannot do that.
Which we cannot do anyway.
And we
But
would never entertain the notion of doing that, so.
certainly, certainly. But my point was merely that we don't know what test they're going to use. So to even speculate at this point about whether our licensing scheme will be upheld in whatever possible future universe exists, it's a little premature. If the court has no further questions, my time is up, and we would rest on the brief.
Thank you, Ms. Eisenhower.
Thank you.
Mr. Davis?
May it please the court, I represent the defendant Thomas Young, and as I understand it, the district attorney has the authority to request that a person be detained under 58A, and if that is so, he did that in this case. It is my further understanding that if such a request is made, the court must hold a hearing and then determine by clear and convincing evidence whether or not the person should be detained. I would simply argue that that is what happened here. And Justice McLaughlin conducted a hearing and could not find by clear and convincing evidence that the defendant should be detained. In my view, case closed.
Thank you, Mr. Davis. Mr. Patton?
May it please the court, Paul Patton representing Jermaine Rodriguez.
Just tell us what his status is, Mr. Patton, right now.
Yes, Your Honor. Bail has been set on him. His case is ongoing. He has a cash bail on him. He has recently been held for a while on a DYS matter, although I believe that he's due to be released from that this week, in which case he would be back on the cash bail, which was set in December. Again, as certainly there was a hearing held here, there was in effect a determination by Judge McLaughlin that the carrying, an unlicensed carrying, was a predicate offense, and the Commonwealth failed to meet its burden. And frankly, that I would agree would be the end of it. I think, however, Your Honors, that saying that unlicensed possession of a firearm is a predicate offense under Section 58A would have the effect of making the residuary clause under 58A into an indeterminate type of clause with great potential for expansion, such as the court found unacceptable in Amy versus Commonwealth. There's a fundamental difference between those offenses which are listed in 58A and this particular offense. And the
Which
fundamental...
which offenses are you talking about? The burglary and the arson?
Burglary, arson, even drug offenses, even the third offense operating under. Those offenses are predicated, the elements of those offenses require behavior in any particular case that even if that behavior wasn't criminalized, somebody would look at it and say, well, there's a chance you can hurt somebody if you do that. On the other hand, unlicensed possession of a firearm speculates as to intent, motive, and what actions the person who is holding that firearm.
Any more than someone who commits arson, who believes the house is uninhabited?
Yes, because by lighting the house on fire, immediately it's fair to say that, look, somebody may come along and get hurt.
But carrying a firearm, immediately someone could come along and get hurt?
The carrying of the firearm in and of
Or
itself...
possessing one?
Possessing the firearm in and of itself is not something that is considered that somebody is going to hurt somebody with that.
Well, why would you have a firearm?
People have firearms for all kinds of different reasons.
At least to hurt animals. I mean, to defend oneself. But
your point is that if you had a license, there's no way you could get here, so what difference does it make?
If one had a license, yes, it would make there would be no offense. The offense is not having the license. The evil, if you will, is the license, not the possession. The problem then becomes that to draw that into the residual clause of 58A, one has to make assumptions that, well, the person possessing that gun without a license is doing it because they are going to use it in some way, as opposed to the person who, through ignorance, inadvertence, or political protest, decides, I'm simply going to hold on to a gun. I'm going to possess a gun. In any of those situations, you cannot say in the first instance, when looking at whether or not something is a predicate offense, what the significance of the person possessing that gun is.
I take it your position that it doesn't help the case to say, well, you have an individualized factual hearing.
No, it does not, because the issue is the step before that. It is what is a predicate offense. Because as soon as somebody is charged with a predicate offense, their liberty is at issue right then and there, long before the hearing is held. Because if they're charged with that predicate offense, whatever it may be, when they're brought into court, if the Commonwealth asks for their 3-day continuance, granted under Mendoza, it has to be for cause, but it's a rather low level, that person will be held for 3 days before they even get their hearing. Second of all, if that person wants to effectively defend themselves at that upcoming hearing, they may have to ask for a continuance, which can be up to 7 days, but which the statute provides. They will be held. So the question of what is a predicate offense in and of itself, regardless of what facts come in at the ultimate hearing, is critical to that defendant's freedom. And that is why if something is going, if the residual clause is going to be to comport with the concept of a 14th Amendment liberty interest, it has to be definite. It can't.
Would you say, is your argument that it would be a mistake to read the statute, the residual clause, as including this, or is your argument, even if it were specific about possession of a firearm, it would be unconstitutional, or is it a combination of the two?
Well, my argument is that it would be unconstitutional to read the residual clause such that it could encompass the firearm. Because of vagueness. At that point, you have to make assumptions. You have to speculate about, again, the intent, the motivation of the person possessing the firearm.
The legislature, if I hear you correctly, the legislature could say, no, we mean firearms, possession of a firearm. Section 10A comes within this statute. They could say that.
They could say that, except I will say that in the amicus brief that has been filed, I would tend to agree that then the question also becomes, would this meet the qualification of an extremely serious offense, such as was pointed to in Mendoza and in Salerno about the types of offenses that it's appropriate to use pretrial preventive detention. In addition to that, I would also say that the problem is the Heller problem, the question of the Second Amendment. And contrary to what the Commonwealth said here, I don't agree that the effect of Heller is not to have, in effect, overruled Cruikshank. The statement that the Supreme Court made about Cruikshank in Heller, objectively speaking, demonstrates Cruikshank to be a nullity, because the statement that the Supreme Court made was that Cruikshank did not use the 14th Amendment inquiry that we require, that the Supreme Court requires as a result of its long line of cases over the past 100 years. Given that, there is no basis on which somebody could go back and say that Cruikshank had any validity. The reason is because Cruikshank said First Amendment and Second Amendment, because they were pre-existing rights, that it was totally up to the states, one way or the other, to protect or not to protect those rights, that the federal Constitution, when it was enacted, only had to do with the federal government. This is totally different from what has developed since that time in terms of analysis of what the Bill of Rights applies to. And so that I think objectively, when one looks at what was said about Cruikshank, it leaves this Court in the situation where the Supreme Court has not, has in effect said that it is open ground, and that this Court, as it did in deciding about the requirement for a showing of cause to have the 3-day continuance in Mendoza, where it said that the Supreme Court had not given any express intimation about whether or not there was a showing that had to make, this Court said that it must, here the SJC, make a decision on that. And consequently, I think that the Court, given what has been said about Cruikshank, has to decide that 14th Amendment issue.
What about the fact that we have said in a past case that firearms, particularly unlicensed firearms, are a risk to public safety?
Again, I think that has to be balanced against the fact that this Court has also said that the mere carrying of a firearm in and of itself is not indicative that somebody is going to use it to hurt somebody. And I'd refer to Commonwealth versus
But that's
Caprese.
correct. That's correct, but that's the mere carrying of a licensed firearm. The carrying of an unlicensed firearm is different.
I don't think that it was going to the licensed versus unlicensed. In the first instance, a police officer could not make a threshold Terry-type inquiry merely on information that somebody may be carrying a concealed weapon. That was Deprezia. Prior to it even getting to the question of whether, in fact, the person was or was not licensed, the mere fact that they were carrying the gun or maybe carrying the gun did not give an inference that there was a danger involved. It's the license that comes in that creates the crime. And my argument for the predicate offense is that you cannot tell that from the face of 58A.
Thank you, Mr. Packer.
Thank you, Your Honor.